Guys, Keller Williams paid $40 million because of texts. Not emails, not billboards, text messages. And they're a massive company with a legal team the size of a small city. You and I don't have that cushion. In this video, I'm going to show you exactly what they did wrong, what the rules actually are right now in 2026, and how to run text message, SMS marketing that doesn't blow up your business. Quick disclaimer before we get in, I'm not an attorney. Nothing in this video is legal advice. What I can do is walk you through the landscape, how I understand it, tell you what I've seen work, what's gotten investors into serious trouble, and convey some of the things that I've talked to my TCPA attorney about. You should talk to your own TCPA real estate attorney that knows telecom laws for your specific situation. Okay, now that my disclaimer's done, let's get into it. The Telephone Consumer Protection Act went into place in 1991, and back then people were getting spam faxes and robocalls, so Congress said, that's enough. There are rules now on how you can contact people, and over time, courts have just expanded this a little bit. First, it covered phone calls, then robocalls, now text messages. So here's the part that keeps me up at night. The TCPA allows individual people to sue you, not just the government. It says that any person who says that you violated the law, they can file a lawsuit and collect $500 to $1,500 per message. So if you sent 1,000 text messages to a skip trace list without their proper consent, that is literally a potential exposure of $1.5 million. And here's the kicker. They don't even have to prove that you caused them any harm. The law just says that they're owed the money if you violate it. And I know that you might be thinking, well, Keith, I'm a small-time operation. Nobody's going to come after me and sue me. I hear that. That's what I thought as well. Here's the honest answer. You're right to think that most TCPA enforcement focuses on larger companies. But here's what's changed. There are now attorneys who literally run ads on TikTok saying, if you've received a text message between the hours of 8 p.m. and 8 a.m., you're entitled to compensation. Like, these attorneys specifically hunt for TCPA violations as a business model. This is what they do. They run ads on TikTok. Go look at it. They subscribe to real estate marketing lists just to get text messages from investors. They send the opt-out. If you don't honor it fast enough, you're going to get sued. It happens. It happened to me. It happened to many of my friends. It's happening all the time. And the statute gives them up to 4 years to file this. So a text message that you sent 1, 2, 3 years ago can still come back to haunt you. Now let's talk about who this actually applies to, because the TCPA does have different rules depending on whether you're contacting a consumer or actually another business. So B2B texting, business to business, has a little bit more flexibility. So if you're texting a property management company, right, like a business thing, and you're texting their business line about a business deal, that's a different conversation. But here's where wholesalers really need to pay attention. When you skip trace a homeowner and then text their cell phone, that is absolutely 100% unequivocally, without a shadow of a doubt, B2C, which is business to consumer. The homeowner is a private individual, right? They didn't ask to hear from you. The highest legal standard applies. And the most common objection that I hear is this. But Keith, they listed their house for sale, so obviously they wanted to be contacted. This is called implied consent. Here's the thing. Listing a house is not consent to receive text messages, okay? A listing is an advertisement. It's not a signed agreement that says, please text my cell phone, or no. I want to receive text messages from all the investors who find my number through a data service, right? These are two totally different things. So here's where most investors, the current system that they're using, it's already broken and they don't even know it yet. Consent is the foundation of everything, right? We've already covered that. So if you have the right kind of consent, documented properly, you're covered. You're in a much better position. Without consent, every text you send is a liability. The TCPA requires something called prior express written consent. 4 very important words. Prior express written consent before you send any marketing text. It needs to be written, not verbal, not implied, not, well, they found our website. No, it needs to be written consent. That means that the person actively agreed in writing to receive text messages from you specifically, knowing who you are, what kind of messages that they're going to get, and how often they're going to receive it. And here's where it gets even more complicated. There's a new FCC rule I don't think that it's actually gone into place. It was originally supposed to get set into effect in January 2025. They bumped it to January 2026, and it's still delayed. But I think that it's still coming. And this is called the one-to-one consent rule. Right now, some pay-per-lead services, they sell lists where the homeowner supposedly opted in to be contacted by investors, right? Under the old rule, that counted as consent. However, under this new rule, one company at a time, you can't use consent that another company collected. The homeowner has to consent from hearing from you specifically. And I know that this sounds like it's designed to shut down wholesaling, and it's not. It's just designed to stop homeowners from checking a box on one website and then getting 470 text messages from 47 different companies. What it means for you is that you need to get your own consent pipeline, your own forms, your own documentation. And there are also some brand new opt-out rules they took into, I shouldn't say brand new, it's been almost a year since they've taken effect. Before, if somebody texted anything other than stop, you could argue, hey, you didn't formally opt out of my campaign. Not anymore. If somebody texts back, no thanks, Keith, leave me alone, stop texting me, or anything that reasonably can be articulated in court of, I communicated that I don't want to hear from you anymore, you are legally required to honor that immediately. This is not optional. This is super important. Not optional, and it has to be automatic. Now, let's talk about 10DLC. Let me explain 10DLC. I see a lot of investors skipping this, and it's so stupid because it's killing their deliverability rate before the legal risk even kicks in. Like, your campaign is going to fail. So A2P 10DLC stands for application to person 10-digit long code. That's what A2P 10DLC is. Application to person, A2P 10DLC is 10-digit long code. That's the system that the major carriers, there's only 3 of them, Verizon, AT&T, and T-Mobile, put into place, and they verify who's sending these bulk text messages. And so what that means in plain terms is if you're using software to send text to motivated seller lists, you have to register your business and your campaign with a central registry before your messages will even be delivered. They will be blocked, okay? Unregistered campaigns will get like 90 to 100% of their messages. They never even get to the person's phone. It looks from your text message software, it looks like you sent out 30,000 text messages, when in fact, 95% of them did not even get delivered to that person. Think about that. You could be paying for the platform, for purchasing the list, skip tracing the list, running this campaign, and 9 out of text messages are going nowhere. They're ghost delivery. And the 1 out of 10 that did get sent, you're still sitting on the legal exposure, right? So the good news about this is that registration is not expensive. It's like $4 or $5, and then each campaign use case is like $15 or $25, and there's like a super small monthly maintenance fee. Point is, it's really cheap, okay? Your SMS platform handles most of this paperwork, and the registration process, we do this for our clients. It's a concierge service. It's like 1 to 2 weeks. Sometimes it can be roughly 3 weeks. So if you're doing this yourself, plan ahead. You can't emergency register the day that you want to launch your campaign, right? It takes some time. And here's the part that trips people up even after they're registered. Let me go through some of the mistakes that I'm seeing here really, really often. Number 1, people are buying these skip trace lists and then they're blasting it out with no prior consent. And this is the riskiest thing you can do, because every single one of those numbers is a potential $1,500 liability. So if you're going to work a list, the text has to come after some other touch point. You cannot just purchase a list, skip trace it, and has to come after they received a mailer and they're responding to the mailer, or a form that they filled out on your website, right? Something that is documented that creates some sort of a consent trail. Now, the second thing that I see is not honoring opt-outs fast enough. Somebody texts you back, they say stop, that has to be processed immediately. Not tomorrow, not when you remember, not once a week from your virtual assistant, immediately. The system should do this automatically. And if you're on a platform that doesn't auto-suppress opt-outs, you need to switch platforms to mine. It's called Dealbase. The third thing that I see is that people are texting outside of permitted hours. So there's a federal rule, right? Federal, that says 8 a.m. to 9 p.m. in the recipient's local time zone. Now, there's a lot of states that are stricter, right? My home state of Florida, Oklahoma, Washington, Michigan, maybe some others that I'm not remembering right now. They all have their own rules. So if you test somebody in Florida before 8 a.m., you are in violation of the state law, even if you are compliant federally, okay? So again, if you are using a texting software that doesn't have not just the federal rules, but the state-specific rules, you got to get one like ours. Also, relying on somebody else's consent is the fourth mistake that I see. So if you bought a list from a lead generation service and they say, hey, these leads opted in to be contacted by investors, that's not your consent. The law is moving to require that you specifically collected and documented the consent from that homeowner. It's not in place yet, but I bet you it will be in the next year. And then the last thing is that you don't have a paper trail. Okay, in a TCPA lawsuit, the burden is on you to prove consent. I have been through one last year. It wasn't on the plaintiff to prove that he didn't have it. So if you can't produce the documentation, you lose. You lose, or you're settling. Your CRM needs to record when did somebody opt in, through what channel, what language they agreed to. This is why we've built this in to our CRM Dealbase. So here's the framework that works. You don't have to use ours. I'd like you to use ours. It's badass. But if you want to build this yourself, use this framework because it works. The first thing that I want you to do is build your own opt-in funnel, right? It's a simple website landing page with a form that says something like, you want a fair, fast cash offer, submit your address. And then in the text below, by submitting, you agree to receive text messages from whatever your company name is about your property. Message and data rates may apply, reply stop to opt out, something like that, right? Clean, clear, it's documented. Take a screenshot of that. Now, pair that with direct mail. Send postcards to your list, and when somebody scans that QR code, pops them over here, and that creates a documented inbound inquiry. You now have an articulatable reason. I think that's the right way to say that. You can articulate, they went to my website, they filled out, the form. I now have a reason to text them. This is a much stronger consent position than just some cold mass outbound SMS blast. The third thing that you should do is register your 10DLC before you need it. Okay, so go through your SMS platform's registration process. Don't dilly-dally on this. Do it today. It takes a little while, right? A week, 2 weeks, sometimes even 3 weeks. Again, we can take care of this for you. It's a concierge service. We don't even charge you for it. If you use our CRM, we do this for you. You don't have to do all the mundane minutia. It's stupid. If you do this yourself, expect 1 to 3 weeks for this. Don't do this the week that you want to launch. The fourth thing that I want to cover is use a platform that automatically handles opt-outs. So there's only a few good options, to be honest, like Dealbase, that are built specifically for real estate investors that handle the 10DLC registration, that handles, automatically, it suppresses the opt-outs and it respects the sending windows, not only on the federal level, but on the state-specific level as well. The last thing that you should do, I know I already said this at the top, but talk to an attorney, right? I mean it. Spend a couple $100s on an attorney, a telecom attorney, to review your specific setup. If you don't have one, I have a TCPA attorney. I'm happy to hook you up with him. He's fairly expensive, but this is cheap insurance. It's cheap insurance. And if you're interested in using our CRM, I'll drop a link to our CRM platform. It's built for real estate investors by real estate investors. I'll drop a link to that in the description below. We handle the A2P and the 10DLC registration for you. We auto suppress your opt-out, so the compliance side is entirely handled for you. All right, let's conclude. Here is the bottom line. SMS is still absolutely alive. It is one of the highest open rate channels in marketing, like 98% open rates. Nothing else even comes close. So all these new rules, they didn't kill SMS marketing. They just killed lazy SMS marketing. The investors who build in a proper consent pipeline, they register their numbers, and they're following these opt-out rules, they're the investors that are still running text messages successfully. The ones who skip the compliance steps, they're not just risking a fine, they are risking a lawsuit that could wipe out everything they made in the last 2 years. Like I said, Keller Williams had $40 million in exposure. You don't. Maybe you have a couple hundred. Maybe you have a couple million. So do the work up front, build it right, and keep it that way. And if you want to see the other side of this, what the full lead generation system looks like when you combine SMS the right way with cold calling, with direct mail, inbound funnels, Dealbase is a really good option for you. That's our CRM, and that's covered right here.